Mr. Muyiwa Shobo joins us now. He's a legal practitioner. Thank you for coming on this morning.
Thank you for having me.
Well, the debate continues. Many still feel surprised and disappointed they didn't see any names, but we heard even from the SCN, the vice president said, look, if you publish those names, it just may jeopardize investigations. Do you agree with that?
No, I do not agree with it. And with all due respect to the clandestine, I think the public has an absolute right to know. I mean, when it comes to criminal investigation and recovery of loot, I think we started off on the wrong ground, though. That is concerning the government. When the government comes out and say, we have recovered stolen or looted assets, you are putting out there that those assets are stolen. And the theft must have been committed by some people. Now, if you compare that and say, well, we have recovered some assets that from witnesses or from those who are connected to this criminal activity, you call it looted funds. Looted means it has been stolen and we recovered it. And it takes you to where we have problems in the Nigerian legal system. I returned to the country a few years ago from the United States, where I practiced for over 2 decades. I enrolled at the Nigerian law school, even this old. But while at the Nigerian law school, I had the opportunity to kind of compare and contrast our legal system, especially the criminal procedure, with what I was used to back in the States. And what I discovered is our legal system, our judiciary, and especially the criminal procedure is still a little bit, lacking in matching our political system. If you look at it, that we have a political system that mimics the United States democracy, but our judiciary, our criminal procedure, are still a little bit in the British colonialist regime. Meaning, in certain instances, you are going to have the issue of the square peg trying to fit into a round hole. And that is the situation we are facing now, especially as it regards forfeiture, recovery of loot, and the issue of plea bargaining.
But aren't we making any, pardon me to butt in, aren't we making any headway with the Administration of Criminal Justice Act?
Yes, a little bit, because I look at it like the learned son mentioned. When it comes to the issue of plea bargaining, we're actually misapplying that term currently, as we say. Plea bargaining has nothing to do with recovery of loot. You don't go to court and say, oh, because you are going to give me what you have stolen, which you have denied the use of the owners. You give me back that stolen loot, then you will not be prosecuted.
Isn't it, if you're deemed to be cooperating with the law, you may, the judge, they say the judge has a discretion not to give you the maximum sentence, but still give you some sort of sentence.
Well, that is partially it, but you have to be in court first. You don't do that outside of the courtroom. You don't, of course, there's what they call prosecutorial discretion, which gives the Attorney General the discretion either to charge you or not. I think that is where we are now, where the Attorney General looks at the case and says, well, maybe I won't charge you. Okay, give me something. That is not plea bargaining. Plea bargaining happens in the court. And plea bargaining has to do specifically with, let me give you an example. You're charged with armed robbery. You go to court. And because of what it will take the prosecutor to prove armed robbery, as in time and money investigation, talk to your lawyer and say, well, what if we reduce the charge to robbery without the armed there? That means you get lesser sentence. And you, as a defendant, look at that. Well, look, if I go with armed robbery, I face the risk of a higher sentence. Therefore, I'll take the plea. That is plea bargaining. You plead to a lesser charge.
You plead guilty to the lesser charge.
But you must plead guilty. And once you plead guilty, you are in court, it is public record. So the issue of disclosure will not even come in. Anybody can walk into the court and say, I just want to plead guilty to robbery instead of armed robbery.
And the catch is that it must happen in the law court.
It has to happen in law courts. It's not something that happens out because it has to do with the approval of a judge. Because during the plea bargaining, I've had occasions where I represented criminal clients. During the process, you even talk to the prosecutor, like, okay, fine. Can I get 3 years instead of 5 years? For my client say, well, we'll look at it and give it to you. But the court must approve it.
Now, in this case, back here now, this matter of publishing the amount of monies recovered.
Yes.
And no names attached to the recovered publication.
Yes.
How does that tie in?
Well, that is why we're having a problem. Because if you're going through the process, you have to categorize, even though I support the disclosure of names, but it's not unqualified. And I'll give you an example. In any criminal issue, you have two parties, mainly. You have the person who is directly connected to that crime, who committed that crime, and you have witnesses. Okay, for instance, if somebody works in an agency, took money from that agency, gave it to Mr. B to do something, Mr. B does not know the source of that money. He has that money. And now the government comes and says, well, Mr. A, who gave you, Mr. B, this money, stole the money. It's our money. And you say, okay, fine. You can have the money back. You are not a criminal suspect. You are, at that point, a witness that can be called to testify against Mr. A. In that regard, your names will not be disclosed because you are a witness. Okay. But Mr. A, who did the stealing, yes, his name must be disclosed because he stole from the public.
So that bit of, because the SAN said here, Mr. Ige said something about innocent until proven guilty.
Yes.
That's one of the reasons why he said names shouldn't be published. He also talks about publishing the names being a hindrance to the investigative process. And it's also going to hinder the process of prosecuting the case. But all of that, from what you're saying here, it's okay to publish the name of the person that stole the money. And that will not in any way hinder the investigations and prosecution eventually?
Well, there's a distinction. Because if you're in the process of being investigated, it is not looted fund. We have not determined whether you are guilty or not. So it's a misuse of terms. And that's where we started. When you guys say looted funds, you are indicating to the public that this money was stolen. The theft must have been committed by somebody. Okay, until that person is proven guilty, he's not a thief. So you cannot qualify that money as looted fund.
But the part where you then said that they started on the wrong footing by giving that toga or that tag, looted funds. So if you go ahead then and publish the amount recovered and the names, so having started on that wrong premise, didn't they put themselves in a bad situation and then let those people be in a situation where they can say, well, you said it was looted funds, we've not been found guilty, so publishing those names means that we are guilty, but we are not, and then we can sue you in that light.
Yes, I mean, you're right in that line of thought, but there's a way out. The government has put itself in that bind. I mean, definitely, by coming and saying these funds are looted. But there's a way out of that, and the way out of that is simple. This money that we recovered them from witnesses for crime. Okay, you can publish and say this man is a witness. These are the accused. I mean, you can publish names. Look, when police arrest folks on the street for robbery, they put their pictures in front of the newspaper.
Even though it's wrong.
Even though it's wrong. I mean, they do it. Well, I don't know whether it's wrong. It's arguable whether it's wrong or not. Because
they've not been found guilty, so publishing the names as such.
Well, even in advanced countries like the United States, for instance, especially when it has to do with public officials, once you are under investigation and you are arrested, they put it in the news, so it's news, because you're a public official, okay? And because you have done something against the public. I practice in the state of Maryland and in Prince George's County, and the county executive, Jack Johnson, was accused of corruption. He stole money. The day that they went to his house to raid it, they called the cameras. They came, as they were arresting him, it was on the news. Well, of course, and he was a lawyer as well. I mean, he was accused at that point. But because he's a public official, the public must know he was the head of government. So if a head of an agency...
Public official.
Yeah.
Now, let's break it down, because it's getting interesting. Because what most Nigerians still don't understand is why is it that first you told us you were going to name these people and you made a U-turn without doing all of that. So if we had some public officials on that list,
yes,
is it okay for the government to let us in on what exactly
it is
has been gotten?
absolutely okay. Our democracy is open, supposed to be open. A public official owes certain responsibility to the public. You are there because of the public. And when you actually violate that trust, the public must know. It's an absolute right of the public. If you're a public official, yes.
What of when you are suspected to have violated that trust?
Even if you're suspected to have violated the trust,
The public still needs
they'll
to know.
just say, they'll just put it a suspect. I mean, they'll just say, this man, Mr. A, B, who is the head of the
So putting the name there actually doesn't mean that you're guilty. It's just for us to know.
It's just for us to know. You're a suspect. And they will explain that. This man he's accused. He's not been found guilty. We have recovered so much as evidence against him, not as looted fund.
But the way it goes here is, even if you write there that, well, we recover this money as evidence, people say, no, this guy is guilty. No, he is guilty. Is that what they could be considering when they say, no, if we publish these names, they will forget about the suspect and go with the toga, he's guilty?
Well, that is a function of what we face in Nigeria when it comes to this corrupt atmosphere. But I still say it. Even, let's put aside the public reaction first. Let's look at what is right. The public will judge you anyway. Okay, and the government cannot say, because the public is going to have opinions, then we will not disclose. I mean, the purpose of the disclosure is to notify the public and to let the public know. So whether they form the right opinion or not is not the problem of the government.
Isn't that part of what the law is looking at here? How you're perceived in the eye of the public? Isn't that why derived defamation, sedition, all those kind of laws?
Yes.
Say, if you defame me or make me look bad in the eye of the public, then you have to correct it.
Well, the other thing is, to defamation, there's absolute defense of truth. The fact that you are a suspect is the truth. And then you can't go and say you are defamed if you are suspected of certain things. Now, you go through a trial, and if you are found not guilty, how are you defamed?
Look at this other angle, because if we don't know the circumstances under which those monies were recovered in the first place, I'm thinking, you were saying, look, some of these monies, when they recovered them, it could be that they just raided the house, saw money. Of course, because they were former public officials, they took the money, and the money, one of them could come to me and say, look, that money actually belongs to my this or that. If that kind of scenario could play out, would it be safe to say we recover this money from this man?
No, it will not be safe to say we're crooked, because you just enter a house, there's money all over the place, and because the person is being accused, then you took it. That is why you cannot even label that money recovered loot. It is evidence against this person. Recovered evidence is different from recovered. If you say it's looted, then you have adjudged the person guilty. But that will take you to the issue of forfeiture in our legal system. Another area in which we are lacking. There's pretrial forfeiture. Okay, over there, you're accused of, and it was seriously litigated over there, whether the government has the right to seize properties pre-trial when that property is not, when the person is not been judged guilty yet. But the Supreme Court, there's a big right, what they call the Sixth Amendment right over there, the right to hire a lawyer of your choice or whatever it is. Yeah. And the argument was that if you seize my property pre-trial, you are denying me the right to hire a lawyer of my choice. Maybe I wanted to hire 50 signs or 20 signs. Now I can't afford it. Now, the United States Supreme Court came with a ruling that says, no, your right to a lawyer of your choice does not include using suspected, assets to hire a lawyer.
So forfeiture, does it also must happen in the law courts?
Well, it must happen in law courts, but it's kind of a low process.